Back in 2007, Massachusetts made it a crime to protest within 35 feet of a reproductive health care facility, better known as an abortion clinic. But protesters complained the so-called buffer zone violated their constitutional rights. And today, the United States Supreme Court ruled in their favor.
We're here to save babies' lives, and that's the whole issue. We're here to stop killing.
It used to be that scenes like this were common outside abortion clinics in Boston and Brookline.
I don't want to call them Operation Rescue. They're terrorists.
But those confrontations virtually disappeared after a 2007 state law made it illegal to stand within 35 feet of a reproductive health facility. Abortion protesters say the law made it impossible for them to counsel women.
Before the buffer zone was expanded, we were able to get up closer to individuals and talk on a more personal level.
In a ruling that has shaken Massachusetts lawmakers, from Mayor Marty Walsh to gubernatorial hopefuls, the United States Supreme Court ruled that the state's buffer zone law violates a protester's First Amendment rights. Today, Ray Neary was back outside the same clinic, but still respecting the buffer zone.
Tomorrow I may come in under the decision after I read it and stand closer to individuals to give them a piece of literature, to show them the alternatives of destroying the child in utero.
But one woman leaving the healthcare facility said while she believes in free speech, she thinks women need some protection.
I think that people ought to have the right to protest, but I also believe in the rights of people to privacy and not to feel harassed. And people who come here for abortions are feeling very vulnerable, and this doesn't prevent them from having the abortion.
Meanwhile, the ruling sends Massachusetts legislators back to the drawing board to come up with something that will pass constitutional muster. Here to help us make heads and tails of this ruling is Bridget Fay. She's a director of Massachusetts Citizens for Life and a member of the board of Pro-Life Legal Defense Fund. Also with us, Jessica Silby. She's a Suffolk University law professor and a member of the Planned Parenthood Advocacy Fund. Thank you both for joining us.
Thank you, Emily.
So, for some reason, this ruling surprised me. Did it surprise either of you?
I wasn't surprised by the win. I was very surprised pleasantly by the unanimous win.
Yeah. How about you, Jessica?
After the oral argument, I expected that it would not go the way that we had hoped. And I'm actually not so surprised by what looks like unanimity. There isn't actually unanimity on the court. There's a pretty wide split between the majority and the concurrences regarding the First Amendment issues.
So there are other states that have buffer zones. Colorado, for instance, has an 8-foot rule between people and then a 100-foot rule between buildings and that kind of stuff. Does this ruling affect them too? I think Montana has it as well. Is it just going to pertain to Massachusetts?
My understanding is it just pertains to Massachusetts and the specific Massachusetts law. And some of it was because, after oral arguments, it was very difficult for the Commonwealth to defend the idea that this law was necessary for all abortion clinics within the Commonwealth.
So why wouldn't it expand? Is it the United States Supreme Court? Why wouldn't it extend to other states that have buffer zones?
The First Amendment jurisprudence requires narrow tailoring in most circumstances, and that requires looking at the facts of each case. And so in Colorado, maybe 100 feet between buildings is actually what is necessary given the history of the protests, et cetera. In Massachusetts, we have 11 freestanding clinics that perform abortions, and the court found today that not all of those clinics are similarly situated with regard to the 35 feet zone. And so they're sending the legislator back to figure out how to more narrowly tailor the zone.
So on the issue of privacy, that the woman who didn't want to go on camera but did speak to us says she's actually an advocate for free speech. You know, she appreciates that part of the ruling. But the part that gives her concern, as she said, was that now this really means that people can be accosted in a way, and you know, it extends beyond abortion clinics actually. But I mean, how do you feel about that?
I think the ruling was a little more narrow in that regards than a lot of people are giving it credit for, because a lot of the focus was on the fact that Mrs. McCullen and other petitioners were sidewalk counselors. They're not there to harass people. They're there to try to provide them with real concrete alternatives to abortion. And the court also was very explicit about the fact that there are ways for the government to constitutionally prevent obstruction of clinic doors, harassment. It said, you know, even normal, benign not specific to abortion context, harassment laws would prevent such harassment in front of clinics. And the basic gist I got from the opinion was the Supreme Court said, please enforce these existing laws before making ones that restrict Mrs. McCullen's right of free speech.
So I think the court went beyond that, and I think the court actually developed sort of a roadmap. There was a beginning of the opinion, Chief Justice Roberts' opinion, where he said there are all these other laws, not in Massachusetts, but in other places. New York has a law about preventing, or New York City, preventing following and harassing a person within 15 feet of a clinic, for example. District of Columbia has an ordinance that prevents the congregating of more than 3 people in front of a foreign embassy, for example, after being told to disperse. So the court actually did give some sense of other alternatives that they thought Massachusetts should go back and try before having this block of 35 feet. I will say it's usually upsetting to states and commonwealths to be told by the Supreme Court to go back and figure out the facts that they've already figured out before. But this court has done that before. They did it with the voting rights case last year, told Congress to go back and find more facts, and that's what they're telling the Commonwealth of Massachusetts today to do.
Does either of you understand the difference between these buffer zones and the bubble zones? Because they left these bubble zones intact.
Floating zones are no approach without consent zones. So within 18 feet of the health clinic, you were not allowed, this is the earlier buffer zone, not allowed to approach without consent a patient going into the clinic. So it was, it mimicked a consensual, it tried to prevent non-consensual conversation. This a fixed buffer zone is a line in the sand that says within this zone you're not allowed to come except for certain circumstances.
So you can so that 18-foot thing still.
Well, we don't have that law anymore. I mean, Colorado has that law. Massachusetts had it in 2000. The problem with the floating buffer zone is that if a protester is standing in front of the clinic and a patient is coming to the clinic to get care, the patient is actually approaching the protester. The protester is not approaching the patient. And so it became very hard to enforce the floating zone in a consensual way. Police officers could not figure out who was approaching whom.
You made a point though earlier, and certainly going back and looking at that old footage, it isn't so much protesting anymore as it is people trying to, they call it sidewalk counseling.
Yes.
What happened to the old protests? Was that not effective?
It's not effective, and when your goal is to try to persuade women to not have abortions, screaming at them doesn't help. They're scared, they're often very young, they feel like they don't have other alternatives. You offer them other alternatives and they will sometimes decide to take them. Screaming just isn't, useful.
Yeah, and was that something that the group sort of consciously made a point of? And
I think it's something that pro-lifers have seen throughout the years, but with respect to this specific case, we didn't bring a protester case. We brought a sidewalk counseling case.
On this issue, I think it's true that the nature of the protesting and conversations outside of the clinics have changed. But one of the things that the earlier buffer zone law had a hard time managing is once there looks like a consensual conversation between a patient and a counselor, in their words, and the patient then rejects the conversation, or the partner of the patient, the person who's accompanying them, often becomes upset. So what is 1 minute a conversation is next minute an altercation, and trying to police that boundary became very difficult. So while I'll agree that I think the nature of some of the protests have changed, and I really hope that there is no violence and no altercations, I think it is often very hard to figure out when a conversation becomes violent.
Well, as I said, this one's going to go back to the legislature for something. Yes. So. All right, Jessica, Sylvia, and Bridget Fay, thank you both so much for coming.
Thank you very much.